Knowing what lawyers think and consider can guide your efforts at getting them to notice you. Some things are obvious and some are subtle. For example, if a lawyer has a high-profile murder case or a $100 million civil liability case, they probably want an expert in their corner that has an established reputation, and someone with testimonial experience as well. They will first look for an expert with that litigation experience, and they will ask attorneys who previously hired the expert for references. They will obviously look for potential experts who have credentials that at least look impeccable, such as those with PhDs. They will also look for experts who have spent a number of years in their specialty. Let's consider some of the subtle considerations made by those lawyers. The case itself will often guide attorneys in the choice between an academic and a hands-on expert. For example, let's imagine a civil suit involving the failure of a blood infusion pump in a hospital's coronary care unit. A lawyer may look for a hands-on engineer who regularly repairs such devices at the hospital. This kind of expert may be more valuable to the case than a PhD in biomedical engineering that designs such pumps. The repair engineer can speak to failure rates, rates of service, and the hands-on issues involved in a hospital. An academically trained bioengineering device designer might be less useful, even though he can speak from an academic perspective about blood pressure issues and rates of flow in such a pump. What does this mean for you? If you have hands-on industry experience, you want to emphasize in your marketing to lawyers the benefit you can bring to them in cases that rely on applied knowledge and expertise. If you have substantial academic experience, you want to emphasize your book knowledge and your teaching skills for cases that rely on theory or design. Lawyers prefer experts that are resistant to Doe-Bear challenges. Based on the Supreme Court ruling in the Doe-Bear case, that could be you if, first, you or the methodologies used in your work have been published in peer-reviewed publications. Second, if your peers accept your chosen methodologies. Third, if you yourself are meticulous in your approach to ascertaining and considering a wide range of possibilities. Next, if your approach to data analysis is extremely thorough, which will satisfy the lawyer who realizes that courts look toward both qualitative and quantitative adequacy of information in expert investigations. I'll expand further on Doe-Bear fundamentals and requirements in later lessons on expert reports, on depositions, and on trial testimony. But your appreciation of Doe-Bear principles and your ability to apply them will help lawyers to decide that you are the expert that can help them. So a very key tactic is that lawyers interpret sociability and likability at your first meeting as a big plus for a hiring decision. As a first consideration, an attorney thinks about the impression you may have on jurors. Beyond that, attorneys actually do have to spend a good deal of time chatting with you on the telephone, meeting with you in conferences, and working with you on affidavits or declarations or reports. Not to mention preparing you for testimony. If you are a bore and they can't even enjoy a meal with you, they'll be less likely to want to spend that time with you over another seemingly equivalent but more personable expert. And so well beyond Doe-Bear considerations, you should put your best foot forward when you do meet attorneys for possible expert witness work.